one. This is the last lecture for contract terms. And what we're going to be doing today is universal human rights and what I call the contractual gateway. So I'm going to take you through a sort of historical discussion of the idea of human rights law coming into contract law, looking mainly at the experience of the United States, and then we're going to look a bit at Germany and EU law, and we're going to look then at the UK, particularly some cases under the Human Rights Act. But what I'd like to do, first of all, to sort of get our bearings a bit, is just go back to what we've done so far. And I'm going to take you through a slightly longer introduction than normal before I get to the essential argument of the lecture. I should say as well that you should have a link for Teams to talk quickly at the end of the lecture. I also know that one or two groups of yours have had changes in tutorials, so hopefully everybody's been reallocated from one of the tutorial leaders who has unfortunately fallen sick. And I think I'm going to be taking a couple of extra groups, or you'll be coming into my classes. So hopefully that'll be sorted out on timetables. So let's start first of all with a quick recap of what we've done so far in these contract terms lectures. So the first lecture that we had after New Year was saying that we've seen across contract law history that there's been this tension between freedom of contract and unequal power. And unequal power usually based on unequal property or the unequal distribution of resources and collective organization, particularly in corporate form and information. So those are the bases of unequal bargaining power. And this really destroys the idea of freedom of contract. There's a big difference between the contractual freedom enjoyed by big businesses on the one hand and corporations bargaining with individuals on the other. So those ideas of freedom of power have been a recurring theme in the history of contract law, ever since the ancients, but particularly since the Industrial Revolution up to the common day, up to today. We've seen the emergence of rights. And alongside the emergence of rights, we've also seen the shift in the way that courts have interpreted contract law. So again, in the first lecture, we looked at how the courts design rules of incorporation of terms into contracts to minimize the effect of onerous terms or unfair terms in contracts. So the more onerous the term, the more notice has to be given. You have the red hand rule, you have inter photo and stiletto, and that all operates unless you've got a signature. But as we've seen after that, the signature rule is diminished with the rise of rights. In the second lecture, we looked at rules on interpretation. So we saw how the courts have shifted from taking a literal interpretation of contracts as they have right across the law to interpretation rules based on the context of a contract and also the purpose behind interpreting. So we see that coming mostly out in commercial cases. Interpretations are a big thing in litigation. What do the contracts mean? But we take a contextual approach, not a literal approach to interpretation after ICS and West Bromwich and all the other decisions following. And then also in that second lecture, we talked about implied terms. And so terms are implied into contracts as strictly necessary, but for a purpose, which is to uphold the reasonable expectations of the parties. So that's been a consistent line of jurisprudence, at least since the House of Lords decision in Equitable Life and Hyman. And although there are some judges who are sort of more or less, let's say, enthusiastic about implying terms, I think that we see a growing distinction between the vigor in which terms are applied between commercial and other cases. So courts are siding, with the idea of freedom of contract when we're looking at two parties that are of equal bargaining power, big businesses. like BNP Paribas and Marks and Spencer. But when we're looking at implied terms, courts are much more protective of the weaker party in cases involving employment, tenancy, or consumer relationships. And so an example of that is Johnson Bloomsbury Health Authority, the poor UCL doctor who had the right to a safe system of work and not be working crazy hours. Um, then we looked after that at the Unfair Contract Terms Act and fair terms, particularly benefiting small and medium enterprises. And the argument that I gave you is that the unfair contract terms is not irrelevant, as Lord Sumption and Lord Neuberger appeared to suggest in at least one case, Parking Iron Beavers. But the Unfair Contract Terms Act is a very important mechanism for ensuring that exemption clauses, exclusion clauses, limitation clauses don't run amok and uphold values of good faith and fair dealing amongst businesses. And then last week we did the Consumer Rights Act 2015, and we saw how the Act establishes, if you like, a positive charter of consumer rights. It doesn't look at the sort of subject matter of a contract or the price, but any other terms are subject to strict control. They can only be, terms have to be done in good faith and not creating a significant imbalance. On top of the extra statutory duties, like products have to be of satisfactory quality, and the person selling has to have good title. So that's sort of what we've done so far, and I think the big movement that we've seen in contract law is one to a sort of from a fictitious notion of formal freedom to more substantive ideas of true freedom and autonomy backed up by rights for people in contract. So the basic point that I want to make with all of that is that the law shifts. The law doesn't stay the same. And that is very important for thinking about, well, what might be the future of contract law. Now, we've been talking about terms in these lectures, but of course we could be asking the same questions about perhaps all of contract law, from the rules on formation, offer and acceptance, to the rules on vitiation that you did last term, and what you'll go on to do, which is the rules on termination and remedies, including damages and injunctions for breach of contract. So the law doesn't stay the same, it shifts. And that we can see that contracts have become more human now than they used to be. And all of this matters, I think, because contracts are the gateway to enter lots of different kinds of human relationships. They're the gateway not just for business and commerce, where we see these values of freedom of contract being prized very highly, particularly by the English judiciary. But contracts also matter for fundamental human rights. And they include these three examples here. It matters for the right to just and favourable remuneration. So that's the right to fair pay and fair working time when you have a job. And, this is important because most of our lives are spent at work. I'm under a contract of employment right now talking to you. This is a part of my work. And so one of the basic values that we have since the Universal Declaration is that there's a right to a fair day's wage for a fair day's work in international law. And if contracts are the gateway to enter into work relationships, the question becomes, well, to what extent should contract and rights be interpreted as a coherent whole? And it's not just that, as we've seen last week, there's rights involving consumer protection. So the Universal Declaration also recognizes that everyone has the right to food and clothing, and we could broaden that to, safe and decent consumer goods more broadly. There's a right to housing recognized in the Universal Declaration, and we'll talk about that a little bit more. So, it's not the case that all human rights are accessed through contracts. So many rights, many human rights, particularly the right to health or the right to medical care, are outside contract law, are largely or more or less outside the system of markets and private enterprise, because in cases like the National Health Service, we decided in the 1940s that everybody should have a human right to health, regardless of how much you can pay. Healthcare should be free at the point of use. So it left the law of contracts and entered the realm of constitutional administrative law. We pay taxes, and as citizens we get benefits from the healthcare service. So not all human rights are related to contract. But of the ones that are, and this is what I want to focus on, of the ones that are, if contract is a gateway to universal human rights, the question that I have is this relevant to our interpretation of the law? So I'm going to give you an argument in a few slides, but what I want to do now is just give a little background, a little bit more background about what this topic involves, because there are a few sort of prior things that I think we need to get established before we start in a larger discussion of human rights. So first of all, well, what are human rights? So, what does this mean? And there's basically a range of different views, and I'm going to give you three. So the first option is that we could say, well, human rights are really nonsense. They're nonsense upon stilts, as Jeremy Bentham once said. He was a lawyer and philosopher who founded University College London. And so if you go up there when the pandemic's over, you can find him sitting in a glass box, because he said, when I die, I want to be stuffed and put in the university. So, if you've ever wondered why UCL is a bit odd, it's probably because they've got a dead guy in a glass box who thought that nonsense on stilts is all that human rights amounted to. And I'm joking, of course, but there is a serious and philosophical point behind what Bentham was saying, which is that human rights shouldn't be recognised as sort of inalienable things or God-given. So Jeremy Bentham was not a religious person, and he saw the French Revolution and the American Revolution, where there were these declarations of human rights being proclaimed as inalienable, and he said, well, that's just not true. I mean, there's no such thing as a sort of a priori set of rights. So that's one view about what human rights are, that we shouldn't really recognize anything in the law as being of any kind of higher value. And the second main view, I think, of human rights is particularly prominent within sort of natural law and maybe also connecting, in sort of from medieval times to theology, which is that there are natural rights or human rights that are sort of outside and beyond human society. So Sophocles in the play Antigone put this quite well, that rights could be seen as like the unwritten and unfailing statutes of heaven. So that is what I think a lot of people around the French and American revolutions were thinking, that there are these rights beyond human society, maybe from God, maybe from somewhere else. But these are things that sort of can't be changed by the ordinary laws of men and women. But then I think there's a third view, and this is probably the one that I prefer, which is that human rights come from our reason, virtue, and knowledge, as it was put by the great feminist advocate Mary Wollstonecraft in a short tract called A Vindication of the Rights of Woman, writing shortly after the American and French Revolution in 1792. So human rights are what we decide we think are valuable as a human society based on our reason, virtue, and accumulated knowledge and experience about what seems to work. And I think also Mary Wollstonecraft put it very well, or opposed this idea of rights, which she said should be universal, not just the Declaration of the Rights of Man, as they said in France, but for women and for every person. And she said that from the respect paid to property flow as from a poisoned fountain, most of the evils and vices which render this world such a dreary scene to the contemplative mind. And so what she was referring to back then is that you can have rights, and that's all very well. But if they are confined to, well, back then, men with property and institutions like property, which not only give people rights but exclude others, then you have, like from poison fountain, many of the evils that flow in the world today. So, her view that human rights are based on reason and evidence, is also connected to a very clear acknowledgement that rights need to be universal in order to be worthwhile. So that is, I think, the third view, and of course, it's up to you to choose which one you like. But as a starting point, I think that those are the main contours of what human rights involve. Now, all of these questions about, well, what are rights and how should we characterize them is very different from another separate debate about the extent to which we should entrench constitutional rights or human rights in a way that Parliament or the legislature can't change them. So there's a very separate discussion about, well, first, what are human rights, but second, to what extent do we want to make certain laws and certain rights harder to change? What's the legitimate balance of power between the legislature on the one hand and the judiciary, if the judiciary oversees human rights on the other. But I think as a starting point, that is a good way to think about human rights. So then we go, well, where do human rights come into the law? And in the UK, this is a little bit complex because, of course, we don't have a codified constitution. We've got hundreds of different domestic human rights found in hundreds of acts of parliament. So human rights are realised in the UK through legislation in the main. However, since a case called the HS2 Action Alliance in 2014, the Supreme Court has recognised decisively that there are certain acts of parliament or certain, as it put it, constitutional instruments which have a higher value according to the judiciary. And those include things like the Magna Carta, which gave everybody the right to common land and the right to use or utilize common land. If you were a commoner, not the king or not a lord, you had the right to use land that was disafforested. You had the right to a fair trial according to the law of the land or your peers. So, there are basic constitutional norms that we've still got today from Magna Carta, which the Supreme Court recognises as having constitutional special value. Another one that it pointed to was the Bill of Rights Act, the Bill of Rights of 1689, which cemented parliamentary sovereignty. And so, that was very important as the culmination of the Civil War and the struggles over taxation in the 1600s. No taxation without representation, and the right to consent to the laws that bind you through a representative parliament. Has constitutional value. And there's the Human Rights Act of 1998, which, as you know from constitutional and administrative law, implements the European Convention on Human Rights, international law. So all these different instruments and many, many others implement human rights into our law as a domestic law matter. But then we've got other sources of human rights that come from international law. We're not just a single isolated country chopped off from the continent and the rest of the world. We are part of a global society, and we have a global international constitution of humanity, at least since the Universal Declaration at the end of World War II. And so there are three main sources of international human rights law. And I think best summed up as follows. Firstly, there's the Universal Declaration of Human Rights of 1948, which I've of course talked about before. So that is a declaration of the United Nations General Assembly. It doesn't have, strictly speaking, value as an independent legal instrument in international law because it wasn't sort of signed and ratified in the normal way as an international treaty. However, it's generally considered by international lawyers as to reflect what we call jus cogens norms, sort of universal norms of international law. And it was implemented through two main treaties and elaborated on two main treaties called the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights of 1966. So these are two treaties that implement pretty much everything in the Universal Declaration and go further, treaties which the United Kingdom has not only signed but also ratified. So that's one main source altogether of international human rights law. A second main source is our regional agreement, the European Convention on Human Rights of 1950. And this is a more restricted document. It doesn't have as many different kinds of rights as the Universal Declaration and the Covenants. But importantly, it is implemented in UK law through the Human Rights Act, particularly Sections 3, which says that the courts have a duty to interpret our law in accordance with the European Convention as so far as possible. Section 4, which says that if they can't do that, they have to make a declaration of incompatibility. And Section 6, which says that courts are public bodies, and like all other public bodies, they are bound to uphold the convention. And then the third source are, sort of lots and lots of just other different treaties, including International Labour Organization conventions that say that you've got a right to organize, no discrimination, no forced labour, no child labour. Those are the core conventions. Or things like the Paris Agreement on ending climate damage, signed in 2015, and of course is important for the future of our environment and the living planet. So this is where human rights come from. And the way that they can come into law is through interpretation. But there are different theories of interpretation of international law coming into UK law. And I think the three main possibilities are these. And just like the other times in which I'm giving you sort of three possibilities, this is open to debate. But I think this sort of broadly outlines where the debates are. So the first way is that international law could come into UK law, or really any country's legal system, through a theory called dualism, and that basically means that the country or the national law is sort of one system, and then international law is just another separate system. So there's a dual system or a dual body of laws. And on a sort of hard dualist theory, international law or treaties only ever come into national law, like the UK, if we've had a positive legal instrument to implement the international law norms. So passing an act of parliament which explicitly writes into our law that we abide by an international treaty. So, for example, the Human Rights Act directly implements the European Convention, and so even under a hard dualist theory of international law, no problem there. It comes in because we've ratified it. Or, another example might be the Paris Agreement saying that we've got to cut carbon emissions, and we've ultimately got to get to zero emissions. So the Climate Change Act 2008, UK statute, says that we've got to have 100% reduction of emissions by 2050. That's too long, by the way, but there it is. So again, international law directly being implemented by a UK Act of Parliament. So one theory is that you don't get anything unless you have a hard positive norm. But the second way that you could say that international law comes into a national legal system is through the monoist theories, which countries like the Netherlands follow. And that says, so long as you've signed up to something in an international organization, or you have the executive of a country has put its name to an international treaty, it automatically comes into national law without any further need for a positive legal instrument by the legislature or statutory instrument. Okay, so the Netherlands follows this idea that if they've signed treaties, it's automatically in the law, and courts have to give it the same value as an act of parliament or something similar. So that's the monoist theory, and you can see that as sort of two ends of the spectrum. But the reality is that most countries probably fall somewhere between those two poles, and I think that's probably the case for the UK. So the third option is that we could say that international law has indirect effect, so that courts have a duty or should interpret national law so far as possible in light of international obligations. And this is the view put forward by, for instance, Lord Phillips, Master of the Rolls in the Court of Appeal in 2001, but the Supreme Court has said very similar things many, many times. The problem is that, so if you are talking about indirect effect of international law, that judges can have more or less enthusiasm. But basically what that is, this idea of indirect effect, is the same as the Human Rights Act Section 3. It's just unwritten and it's uncodified. It hasn't been put into an Act of Parliament. And we see more and more of this happening through the Supreme Court's jurisprudence. In trust law, you'll do a case called FHR, where the Supreme Court interprets the trust, our own trust law, or equitable principles, in light of the conventions against bribery. So reinterpreting equity according to international conventions that we've signed up to. Or another example in labour law is Hunger and Allen, interpreting the rules on illegality in contract law, contract of employment, in light of rules against trafficking for vulnerable migrants. Okay, so those are three different ways in which international law can come into UK law. But I think it's especially important to start thinking about this more systematically now, because in the UK of Brexit and the departure of the United Kingdom from European Union membership in all its glory, and also just because of our globalizing economy. So, right around the world, we are inevitably going to have an increasingly integrated economy and society and probably culture as well. So international law is going to become ever more important to every aspect of our lives. Okay, so all of that is just a bit of backdrop because you might not have got entirely there in public law yet and need to say something about international law too. So all of that is backdrop to ask, well, how should contract law and rights be interpreted where they intersect? How should contract law and rights be interpreted where they intersect? So I think a good guide to start with is this phrase from Otto Kahn Freund, a great European labour lawyer, family lawyer, also contract law, who fled Germany in the 1930s because of the Nazis and came to live in London. So Otto Kahn Freund famously wrote that the power to interpret, himself having been a judge before, the power to interpret is the power to destroy. So when we're interpreting what contract law should mean, when we're interpreting what human rights law should mean, the courts giving interpretations has the power to nullify the existence of any rights or any duties if they want. The power to interpret is the power to destroy. But also interpretation can construct. So just as judges can read down, in their power as a judiciary, they can read down rights, they can read down contracts, they can read down statutes. They can also build them. They can have positive interpretations which abide by the norms that they think are important. And the view of another judge from Israel called Justice Barak in Constitutional Human Rights and Private Law, an article in 1996, argued that human rights should be applied, albeit indirectly, so taking interpretation number 3, to relations between private citizens, and that in contract law the tools are all there to do this. So open textured norms, he pointed to good faith, public policy, and unconscionability. So good faith, which we've seen a little bit of in a couple of lectures ago in implied terms, unconscionability, which you touched on last term. These open textured norms are the vehicles through which to bring in human rights interpretation. And to that, I suppose we could add, for English law, the rules on interpretation and implied terms, particularly to uphold the parties' reasonable expectations. So, the idea that every party is entitled to expect that human rights are upheld in their contractual relationships as much as anywhere else. And I think that the big point about interpretation, I'm just going to turn my camera slightly, is that it's always possible when you're interpreting something to interpret things in more than one way. And I just say this because I think that you might have been wondering, what on earth this picture behind me is while I've been doing the lectures. So this is a poster which my partner got from the Bauhaus Ausstellung. And if I just raise that slightly, you should see that it's an oblong or a set of rectangles And I'm just wondering, does anybody, can anybody say what that looks like? Perhaps quickly in the chat. Because when I first got this, it took me a while to figure it out. Does anybody see a picture there? Or does it just look like a random set of rectangles? Well, I'll tell you what. I don't know if anyone's a face. Yes. Now, and I say this because when we first got this, when we first got this picture, I just thought it was a random set of rectangles. And after about 2 years of sort of walking past this, and I suddenly noticed, hold on, that's a face. Oh, so somebody else sees a gun for some reason. Yeah. Well, I mean, this just goes to illustrate the point that when we look at things, whether it's a poster from sort of 1920s uh, modern art and design, you can always interpret the meaning of things in a number of different ways. And random set of rectangles or a face, it could be one or the other. And I think the same goes for contract law and statutes. There are always different ways in which we can interpret words, and we can make choices. And the question is whether we want to make choices that uphold society's basic values, and also, I suppose, well, what those values actually are. Okay, so now we get to the crux, which is I think that the UK courts are not going as far as they should in upholding human rights. They're not going as far as what Justice Barracks suggested in the 1996 article. And that was represented in a recent Supreme Court case called McDonald and McDonald. And I'm going to come back to this again a little bit later, but I think it's probably worth just explaining the facts of this decision. And before I get into the judgment that I want to argue against. So this was really a landlord and tenant case, but it's also about contract because contracts are the gateway to the right to housing and also the right to a private and family life under the European Convention on Human Rights, Article 8. So in this case, McDonald claimed that a bank's notice to quit her tenancy under what's called the Housing Act of 1988, Section 21, violated the European Convention on Human Rights, Article 8. So that, as I said, is the right to a private or a family life. And if you interfere ordinarily with somebody's human right, then you've got to show that the interference is proportionate and done in a way that is necessary in a democratic society and complies with the rule of law and a certain set of other exceptions and rules. But what Section 21 of the Housing Act of 1988 says is that landlords can get a possession order from a court, or the owner of a house, more broadly, can get a possession order from court against a tenant who is renting when a tenancy ends, and without really any elaboration on reasons why that might be possible. So since the 1980s, for most tenants, there are still some rights, but for most tenants, people can be evicted without having to provide good reasons. This was particularly important to McDonald and McDonald because Miss McDonald had very serious mental disabilities. She was prone to psychotic episodes, and so she's a very vulnerable person. Also, somebody that had been moved on from council housing before because she created problems for, I suppose, neighbours. But so she is a vulnerable person with a disability, and she had housing benefit. But the problem was in the tenancy where she was at, her parents had been paying off mortgage installments and they had not kept them up, so the bank had sought a possession order against her. And the court was given evidence that this would, if she was evicted, this would be very, very bad for her health. So the question was whether the court had to interpret the law under Section 21 of the Housing Act 1988 and her contractual rights in a way that didn't infringe upon her right to privacy and a home life. So one question was, whether the right to privacy and a home life under the European Convention actually extends to protecting a vulnerable person against eviction, and that wasn't actually made out according to the Supreme Court at all. But for our purposes, what I want to focus on was the engagement with the contractual rights. So, could she be evicted was one question, but then also how do we interpret the interplay between contract and statutory rights and human rights? The Supreme Court holds that there was no violation of the notice to quit, and it said that even if it needed to, then it would have held that Article 8 didn't prevent her eviction. But then it also added, and actually this was central to the judgment, that because because legislation regulated the matter, contractual rights, the right, which didn't give you contractual rights set down in the tenancy document that didn't give you any possibility of claiming that you were evicted for a bad reason. Contractual rights should be presumed to be compatible with the European Convention on Human Rights. And this was a unanimous decision, Lord Neuberger and Lady Hale giving the judgment with which Lord Carr, Lord Reid, Lord Carnwath agreed. But it is a combined judgment, and so that makes you wonder whether everybody entirely agreed with everything that was said in the judgment. The bit that I want to criticise is this. In paragraph 37 to 41, the Supreme Court says the following. The European Convention on Human Rights, they say, is intended to protect individual rights against infringement by the state or its emanation. A domestic court would be regarded by the Strasbourg Court as part of the state, and therefore obliged to respect individual rights enshrined in the Convention. So it's making this opposition between individual rights and the state. It says it's not open to a claimant to contend that Article 8 could justify a different order from that which is mandated by the contractual relationship. Mandated by the contractual relationship. We can't look at human rights if it's different from that which is mandated by the contractual relationship between the parties. But then it says, at least where, as here, there are legislative provisions which the democratically elected legislature has decided properly balance the competing interests of private sector landlords and residential tenants. So the phrasing in this paragraph is, I think, a little bit opaque because what they seem to be saying really is that you can't interfere with the legislative balance set, for instance, in the Housing Act, based on human rights interpretations. I mean, a declaration of incompatibility could be a different story. That's ultimately what seems to be said in paragraph 40. But before that, it seems to highlight the idea of the sanctity of the contractual relationship, which I think is highly problematic. The Supreme Court says after that in paragraph 41, to hold otherwise would involve the convention effectively being directly enforceable as between private citizens, so as to alter their contractual rights and obligations. Whereas it claims the purpose of the convention is, as we mentioned, to protect citizens from having their rights infringed by the state. And I don't think this can be regarded as correct. So the main arguments that I want to put forward over the rest of this lecture are as follows. Responding to the general question, should human rights alter private contracts? The first main argument that I have is that the UK Supreme Court went too far in its suggestions that human rights, including under the European Convention, are mainly to protect, or are mainly there to protect the individual from the state. Because corporations can threaten people's rights just as much, so banks or big tech companies or big oil companies, corporations can threaten rights equally or sometimes more. And rights should work between private citizens in full force, or as people sometimes say, horizontally between private individuals, not just vertically between the individual and the state. And if we were doing a longer lecture on human rights, I think I could make that pretty clear. particularly through the right to freedom of association under Article 11, operates between workers and employers, so between private parties. And it's very clear that all kinds of other human rights operate in the same way. So the UK Supreme Court, to the extent that it tried to make a hard distinction between rights operating only between the individual and the state, I think was going too far. The second main point that I want to argue is that there's no neutral position on rights. So if we say, that the court is not taking into account human rights at all, it's just leaving private parties to arrange their contractual affairs, and that human rights should not enter into the contractually mandated relationship. This is not being neutral, far from it. It's elevating certain rights of certain people over other rights of other people. In particular, if we say that human rights, as we see in the Convention or the Universal Declaration, don't interfere with contractual or private relationships, this is really elevating the rights of property and particularly rights of corporations over the rights of other people, such as consumers, workers, tenants, or rights to a clean environment. And it matters which rights we have. It matters which rights we have, and I think that the Universal Declaration is the best guide. And the third main point that I'm going to try and get across is that we should be interpreting all law, including contracts, as far as possible to uphold universal human rights, not saying that we defer to the contractually mandated relationship. Not doing so, not doing this, harms society. And as I'm going to try and convince you, we've seen that again and again throughout history, starting from the beginning of the US civil rights movement and going onwards. I'm not arguing necessarily that McDonald and McDonald was wrongly decided, because I think that the Supreme Court did make a decent point about the extent to which the European Convention goes, but that is a separate discussion. The main point that I want to try and get across is that human rights should be applied across contract law and indeed all law. And we're going to go now through the United States, the German and EU experience, and the UK experience to see how that can be done. Okay, so now let's start with rights and contract in the American experience. And I know I talk about America a lot, but the Americans do courts and litigation very well, and there's a big long history, and that has really informed a great deal in what we do in Europe and indeed all around the Commonwealth or the rest of the world. So we're going to start with something called the civil rights cases, and then we're going to go through the Lochner era and how that worked into the Universal Declaration of Human Rights. So if we rewind in history to the US Civil War, beginning in 1860, this was fought because you had the succession of the slave-owning southern states organized into what they called the Confederacy against the Union. So the Confederacy was, of course, the racist South. And they've still got supporters today, like the goons and the thugs and the terrorists that stormed the US Capitol at the beginning of January. And they wanted to secede from the rest of the United States, basically because President Abraham Lincoln was elected to the presidency, and he had spoken many times about his opposition to slavery. So the South secedes, and this triggers the Civil War as people in the North and also in the South seek to defend the Union against the succession by the slave-owning despots that were running the states in the South. So Lincoln, during the Civil War, issued the Emancipation Proclamation of 1863, declaring an end to slavery. And as part of, ultimately, of course, the North wins the US Civil War. Unfortunately, tragically, Abraham Lincoln is assassinated. But as part of the post-war reconstruction of the United States of America, a few different constitutional amendments are passed. And one of the most important was the 14th Amendment in 1868, where Section 1 said the following: all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States, so you can't be deprived of citizenship or personhood, giving you the right to contract, the right to own property, and everything else, and of the states wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law. No person shall be deprived of life, liberty, or property without due process of law. And of course, this was targeted at the southern states, which had systematically denied people who were enslaved of their personhood and of their liberty, and didn't only say that they couldn't own property and make contracts and so forth, but that they were property and they didn't have due process of law, nor to deny any person within its jurisdiction the equal protection of the law. So that was one of the post-war Reconstruction amendments to the US Constitution. But as I say, the power to interpret is the power to destroy. And so what happened after the Civil War is that many judges from the South got their way onto the Supreme Court and promptly began to shred the post-war Reconstruction amendments that attempted to create a more equal society. So it wasn't only the amendments to the Constitution, but there were also acts of Congress, particularly the Civil Rights Act of 1875, that were designed to implement the constitutional amendments. So the Civil Rights Act of 1875, it entitled everyone to access accommodation, to access public transport or theatres, regardless of the colour of their skin. But the Supreme Court held that this act violated, unbelievably, the 14th Amendment's due process clause itself. Now, let's just also remember back to the offer and acceptance rules when you were doing, whether something counts as an invitation to treat or an offer, and I don't have any obligation to you if there hasn't been an offer, if there's just an invitation to treat. All of this directly connects to the Civil Rights Act of 1875, because this was about stopping people having the power arbitrarily to deny people access to basic goods and services like public transport, accommodation, housing, or theatres based on the colour of their skin. So this was one of the first anti-discrimination laws in world history, one of the most important, and it was torn up by the racist majority on the US Supreme Court in the civil rights cases of 1883. And the way that the majority reasoned was as follows. Justice Bradley held that the 14th Amendment did not authorize Congress to create a code of municipal law for the regulation of private rights, so rights between private individuals, including employers, landlords, corporations, and other people. And this was supposedly distinct from the regulation of state laws. So, a division between laws operating between private parties or private law and public law on the other hand. The constitutional amendment, he said, the 14th Amendment, was only intended to be able to regulate public law. And of course, this was nonsense, right? I mean, this is a tendentious, perverted interpretation of what the 14th Amendment was meant to be about. But they didn't care because they were pursuing an openly racist political agenda designed to ensure that black people in the South, in the southern states of the United States, were denied equal treatment. One of the most famous dissents in American history is this one from Justice Harlan. He said that he would have held, unsurprisingly, the Civil Rights Act of 1875 to be constitutional and valid, because if you took it away, people would be left practically at the mercy of corporations and individuals wielding power under public authority. So he rejects this distinction that there is a rigid divide between public laws, which are the object of constitutional regulation, and private laws like contract are operating between individuals. And that's because, he said, private power is just as real as public power. And when the state delegates to corporations, the rights of private property, the rights of contract, to enforce private property rights, to enforce binding contracts with other people, this in itself is a public issue. And this in itself is the exercise of power, which courts can't wash their hands of. So the denial of rights against private parties was the denial of the right to go to a public court. Effectively, Justice Harlan is saying there is no tenable public-private distinction. But Justice Harlan remained in the minority for a long time, and this became what was known as the Lochner era. Freedom of contract became a constitutional principle, as I've mentioned before. So, out of this right, the idea that in the civil rights cases that even the legislature couldn't interfere with rights of private property, the Supreme Court went further to say that liberty of contract, as part of due process of law and liberty of contract or freedom of contract was a constitutional principle, and promptly struck down all kinds of social and economic rights legislation that would benefit working class people, particularly black people in the South, and women, any group that was vulnerable that wasn't a property owner. So the case that gave its name to this era is called Lochner and New York in 1905, and this was about New York State passing something called the Bake Shop Act of 1895, and that limited the working day for bakers to a maximum of 10 hours, which is still pretty long, but at least there was some limit, and 60 hours a week. Again, far too long. The current limit in EU law and UK law is 48 hours a week, unless you opt out. But this was the start of an important piece of working time rights legislation. Now, Mr. Lochner was fined because he was making his workers, his bakers, work longer in his bakery than the Bake Shop Act of 1895 had mandated. So he was fined, and then he argued that his fine was unconstitutional because, he said, the 14th Amendment of 1868 made the whole statute unconstitutional. He said that this idea that the state shall not deprive any person of life, liberty, or property without due process of law was taking away his liberty to contract on any terms that he wanted with his workers, and essentially to make his workers work as long, because really the contract between an employer and a worker isn't one of equal power. Usually the employers are dictating the terms. So that's what he was arguing, that this statute violated his constitutional rights under the 14th Amendment. Again, something that was passed to benefit people who were previously enslaved is now being argued to be something that benefits an employer who's making people work very long hours. So the US Supreme Court held 5-4 that the Bake Shop Act was indeed unconstitutional because it violated a reasonable use of state power. Somebody's just asked, does the 48-hour rule apply to lawyers? It certainly does, except people often opt out. So this was the reasoning from Justice Peckham. Justice Peckham, in the majority, said that liberty of contract relating to labour includes both parties to it, worker as much as employer or employer as much as worker. The one has as much right to purchase as the other to sell labour. Of course, it's not really true, is it? Because the employer has a lot more money to purchase the labour of the worker. That's precisely why they are in that relationship. Justice Peckham says there is no reasonable ground for interfering with the liberty of person or the right of free contract by determining the hours of labour in the occupation of the baker. There's no contention that bakers as a class are not equal in intelligence or capacity to men in other trades or manual occupations. But of course, nobody was really arguing that bakers are stupid and that's why they're signing up to contracts. But what the argument is, and the argument of the New York legislature, was always that bakers lack economic power and able to bargain for terms which are just and fair. So that was the majority, and in the minority, growing a bit this time, is Justice Holmes dissenting, saying that the Supreme Court shouldn't be striking down these kinds of acts of well, in this case, the New York State Legislature, because he says a constitution is not intended to embody a particular economic theory, whether of paternalism or the organic relation of the citizen to the state or of laissez-faire. A constitution, he says, and more broadly we could talk about human rights, is made for people of fundamentally differing views. It should be something that protects people universally, not a weapon that is used to protect property owners or corporations against workers. Justice Harlan is also still on the court, and he also gives a dissent. Now, that's all going on in America, and I just want to jump back to what's happening around the same time in the United Kingdom, because we did have a sort of Lochner era of our own. It's just that it worked out a little bit differently because our Parliament is much more powerful, and the courts can't strike down Acts of Parliament. Something that results, of course, from the settlement in the Bill of Rights Act of 1689. But we did have a hostile judiciary that systematically attempted to attack social and economic rights, particularly targeted at the working classes and women. So in Taff Vale, one of the most notorious cases, the House of Lords held that trade unions could be liable in tort if workers broke their contracts by going on strike. And the strike, of course, like most strikes, is about trying to get fair wages, fair working conditions for people doing jobs. So Taff Vale was, a basic attack on the right to freedom of association. It caused the formation of the Labour Party in the UK directly, but it was quickly reversed by the Trade Disputes Act of 1906 under the great reforming Liberal government, and with a renewed Labour Party, which was led by Asquith, and later also Winston Churchill was involved, Lloyd George. Then there's an example of Roberts and Hopwood in 1925. So around that time, it was still the case that only men could vote over the age of 21, and women could only vote if they were over the age of 30, because somehow it was believed that maybe women were less mature, and also only if they had property. So before, men had been restricted to the property qualification, and in 1918 the Parliament decided, well, we're only going to let women vote if they have property. So explicitly sexist in this time, and this went from Parliament to the courts. In Roberts and Hopwood, the House of Lords held that a local council could not have equal pay between men and women for its staff, and Lord Atkinson said that the attempt to have equal pay between men and women was ultra vires and motivated by, quote, some eccentric principles of socialistic philanthropy or a feminist ambition to secure, oh my God, secure equality of the sexes in the matter of wages and in the world of labour. So, it took a few years later, but in the 1928 Act, the Representation of the People Equal Franchise Act, finally men and women got the vote, but it was a few years until equal pay was sort of recognised as a statutory right. Nevertheless, we had a stronger Parliament that could reverse some of the poorer judgments, but the basic point is that we had the same hostility of the judiciary in the UK. Now, the Lochner era ended only with the United States going into the Great Depression and the victory of President Roosevelt, leading to a switch in the way that the US Supreme Court thought about its own role and the balance of the judiciary. But before that, throughout the so-called Lochner era, the United States Supreme Court struck down act after act. So, until 1936, some examples were it struck down a ban on child labour, if you can believe it, in Hammer and Dagenhart. It struck down the right to a minimum wage in Adkins and Children's Hospital. So states and the federal government is legislating, and the Supreme Court is just saying, no, we can't have any of these rights. It struck down consumer protection legislation in the National Industrial Recovery Act of 1933, which we mentioned before. It struck down the right to join a trade union in Adair, through something called yellow dog contracts. it struck down the regulation of employment agencies in Adams and Tanner. It even struck down old age pensions. Sorry, not the Supreme Court, but the state Supreme Court of Arizona, in a case called Bucksteger. So all of this left Americans in the 1920s without very much social or economic protection, without fair wages. The economy was booming, but really benefiting people at the very top, large corporations, large banks. But people didn't have fair wages. They had very precarious pensions. And so millions saved, as I mentioned before in previous lecture, in the stock market. And this created the Wall Street bubble and then crash in 1929 as people lost all of their savings in the burst. So the Wall Street crash ensued or led to the Great Depression. The Great Depression led to the election of the Roosevelt government and the New Deal, designed to rescue American capitalism out of the depths of 20% unemployment. The Supreme Court continued to block laws passed by the Roosevelt government until Roosevelt won, I think it was 48 out of 50 American states in the presidential election, and threatened to pack the court or expand the court with judges that weren't going to interfere with his democratic legislative program. And one judge switched in time in a case called West Coast Hotel and Parish, and the New Deal continued. But all of this experience in the 1920s, 30s, and right back to the civil rights cases of 1818, led people in America and feeding into the Roosevelt administration to think very differently about the proper role of rights. So were constitutional rights just supposed to be about the relation of the individual to the state, mainly to do with civil and political rights? What about social and economic rights? And this is where we come to a shift in the US Supreme Court in a case called Shelley and Kramer, recognizing essentially in majority what Justice Harlan had said before. There are cases which involve, like this one, which involved housing. There are cases which involve the exercise of private power that the courts have to recognize. And the exercise of private power isn't purely private, because states have made available to individuals the full coercive power of government to deny certain people rights if they grant rights of property to others, to corporations or to landlords. So the exercise of private power is just as much an issue for the public. And this comes into the Universal Declaration. And I think that I've just I'm sorry. I was wondering. I thought I skipped over a slide somehow. I missed this one. Before we get to the Universal Declaration, and I should have said this before, Shelley and Kramer, the Roosevelt government argued in the 1944 State of the Union address that it wasn't just civil and political rights that should be acknowledged in the law. It was also social and economic rights. So he says this republic had at its beginning the protection of certain inalienable political rights like free speech, free press, free worship, trial by jury, freedom from unreasonable search and seizures. These were our rights to life and liberty. But, he says, as our nation grew in size and stature, as the industrial economy expanded, these rights proved inadequate to assure us equality in the pursuit of happiness. We came to the realization that we cannot have individual freedom, or it can't exist without economic security and independence. Necessitous people are not free. People who are hungry and out of a job are the stuff of which dictatorships are made. And we've recognized that in our day, economic truths have become also self-evident. We should have, he says, so to speak, a second Bill of Rights, which form the basis of security and prosperity. So that was the sort of final recognition at the end of Roosevelt's government of the need to construct economic and social rights and to see this as on an equal footing as civil and political rights in the law. Okay, now I've got the slides in the right order. we can get to the Universal Declaration, because this really implements in international law precisely what Roosevelt was saying in 1944. The Universal Declaration sees that the right to property in Article 17 is an important human right, and out of the right to property, of course, flows the right to contract with my property. So this pen is my property. I can sell it to you, or we can trade with it. So contract sort of flows from property. And property is an important right enshrined in the Universal Declaration. But it's not the only right. So there are these other rights, economic and social, particularly from Article 23, like the right to work, to free choice of employment, the right to not suffer discrimination, like the original 1875 Civil Rights Act said. The right to just and favourable remuneration, the right to join trade unions, the right to rest and leisure, holidays with pay, the right to a standard of living for health and well-being, food, clothing, housing, medical care, sickness, protection from sickness and old age. So all of these rights come together with private rights of contract and property, and they all should be interpreted together in a harmonious way. There's not necessarily rights of property ranking on a higher plane to other rights, or civil and political rights are there as well, in the Universal Declaration, right to privacy, for example, in Article 12. But these rank exactly the same as other economic and social rights. There wasn't sort of one before the other. And that is the system of international law that we have represented or given effect in the International Covenants of 1966. So we're going to concentrate on Europe now. And we're going to go through, I think, some of the leading examples of ways in which human rights come into contract law, and give you some examples of some leading cases. So we'll go through Germany in the EU, then we'll look at the UK and the European Convention on Human Rights before concluding. So a little bit of context to the German situation is that under the 1949 Grundgesetz, or the German constitution, the basic law, there are a list of human rights which include the right to private autonomy in Article 2 and freedom of expression in Article 5. So this is pretty similar to the European Convention on Human Rights and what is found in UK law as well. Also, Germany has a civil code which includes contract law. This is called the Bürgerliches Gesetzbuch in my bad German, or so it's almost like the bourgeois law book or law code of 1900. But so that contains the basic contract rules, and it also requires in paragraph 138 that contracts are performed in accordance with public policy, and under paragraph 242 in good faith. And again, that's not really dissimilar from the United Kingdom, because although we've got a debate about the extent to which good faith comes into the law and what it means, we have terms implied to reflect reasonable expectations, and it's well established that contracts cannot violate public policy. We've just got debates about the scope in which public policy operates. And in one of the first cases, actually a tort case, a defamation case called the Lute judgment, it was held by the Supreme Court that a fascist filmmaker could not sue a politician for defamation after he publicly called for a boycott of the film. So the politician says, don't go and see that film. The filmmaker sues for, or wants to sue for defamation, because it was said that an action in tort had to be interpreted compatibly with constitutional rights, the right of freedom of expression for the politician to say, don't go and see the film. So that was the first time in which constitutional law came into, if you like, private law, the law of tort, which is about rights between people when it comes to things like accidents and negligence. The protection of life, liberty, and property. But for our purposes, the big contract law case is from the German Constitutional Court called the Bank Guarantees Decision, or Bürgschaft Decision, in 1993. So this was a couple of joint cases where lenders had required spouses of mortgagees to guarantee their partner's debts. So very similar to the ones that we saw last term in misrepresentation and undue influence, like Royal Bank of Scotland and Ettridge, or Barclays Bank and O'Brien. Here you had spouses guaranteeing the mortgage repayments on the home to to banks, or guarantees of partners' debts. And the question was how this intersected with human rights when homes ended up being repossessed. So in the first case, a 21-year-old daughter guaranteed her father's debt of 100,000 Deutschmarks. So I guess that's about 50,000 euros, 45,000 pounds. Guaranteed her father's 100,000 Deutschmark debt to a bank when she had no job. So she was either being very optimistic or probably not quite as well informed as she could have been. She was misled by the bank about the seriousness of the obligation, so that was accepted on the facts. And the second case was where a wife had guaranteed her husband's debt, which eventually meant a debt of 16,274 Deutschmarks. And the bank knew that she could probably not work because she also had the job of looking after the couple's children. And so the question was whether there could be repossession orders given the bank's conduct. The Constitutional Court held that claimant 1 had the right to cancel the obligation, but the second claimant did not. So the 21-year-old daughter wins. But what's important for us is the reasoning. So you could have probably got there on the reasoning that you saw in Ettridge or O'Brien about undue influence and misrepresentation. But the court says the following. The claimant's objections concern the interpretation and application of general clauses in the Civil Code that control the content of contractual obligations in civil courts, primarily good faith and public policy. In construing those clauses, the basic right of private autonomy, constitutional right, and the right to develop one's personality, also constitutional right, must be considered. And the civil courts failed to do so in the initial proceedings. So the right of autonomy as a constitutional value, which is basically true freedom of contract, should be considered. In contract law, it goes on to say a just balance of interest results from the concurrence of wills. Contracts should be about free concurrence of wills amongst the contracting parties, both between themselves and, in so doing, protect their own individual freedom of action. But, it says, if one contracting party has such a strong presence that he can factually determine the contract's content unilaterally, this means that the other party loses autonomy. So the Constitutional Court is saying inequality of bargaining power destroys freedom of contract. It's not really freedom of contract. And that's the case when you've got a bank making a contract with an individual. I'll skip over the next bit. In cases of typical types, when one party to a contract may be recognized as being structurally weaker, and if the consequences for the weaker contracting party are significantly imbalanced. Okay, so remember the language of significant balance in the Consumer Rights Act 2015 and the unfair terms legislation. If the consequences for the weaker party are significantly imbalanced, the civil law must react and make a correction possible. This follows from the fundamental guarantee of private autonomy and also the principle of the social state. So it's saying there that we're interpreting contract law in light of constitutional values and constitutional rights. When you've got open clauses and we can interpret the law in more than two ways or more, then we should do so in light of the values that underpin the law, particularly in the Constitution or in human rights. It says, if the content of a contract is significantly onerous and obviously unreasonable as a balance of interests, the court may not content itself with the conclusion that a contract is just a contract. On the contrary, it must clarify whether the provision is the consequence of structurally unequal bargaining strength and, where appropriate, make correction within the framework of general principles of civil law. Okay, so there you see an example of a big European Union member state, Germany, and its constitutional court saying that we've got to have contract law that is interpreted in light of human rights. Now, you could get to the same results without human rights, but what human rights are doing, or what constitutional norms are doing, is they are bolstering the interpretation and saying, well, if there's ambiguity about what you should choose, you should go with the rule that upholds human rights. So now we come to what the European Union law does, and particularly how the Court of Justice of the European Union in Luxembourg thinks about similar issues. In the EU, there is a document, as you'll know, called the Charter of Fundamental Rights of the EU of 2000. And this was written to, if you like, codify what member states' human rights traditions all say. So it's generally accepted that the Charter of Fundamental Rights reflects what other member states' rules already have, at least at the bare minimum. So many member states have human rights which are more protective. You can think of many examples like the right to develop one's personality in the Grundgesetz. I don't think is in the Charter. I could be wrong about that. There's a right to travel in the Italian Constitution, which isn't in the Charter of Fundamental Rights. But this is what's supposed to be at least a baseline as generally accepted human rights norms in the EU. And two are important for our purposes, just for the examples in the cases that we're going to see. First is Article 7, which says that everyone has the right to respect for his or her private and family life, home and communications. So that's also reflected in the ECHR, we'll see it again. And then there's also Article 8, which says that everyone has the right to protection of personal data concerning him or her. And so when I talk about corporations as being a threat to human rights, I think this one is really important because everything that we are doing these days is online and basically going through Microsoft, if it's Teams or if it's email, or Google, again, if it's email or search functions or just all the things that Google does. This is YouTube. So here we've got a personal data issue. Facebook, WhatsApp, Instagram, and all the others. I don't know how many of you have TikTok, but yeah, personal data is really a big thing, and it is protected in Article 8 of the Charter of Fundamental Rights. We've also got, as we've seen already, a reference to the right to a high level of consumer protection, or at least union policies programmatically are meant to guarantee that. And in Article 47, it says everyone whose rights and freedoms are guaranteed by the law of the Union have the right to an effective remedy. So we see that, timeless common law called Ashby and White, going back to the 1700s, the right to a remedy, because a right without a remedy is a vain thing. So this is a fundamental human rights norm as well in the EU. And Kusinova and Smart Capital is a really good example of how the Court of Justice of the European Union has been bringing human rights reasoning into its jurisprudence. In this case, as we've seen already, on the Unfair Terms in Consumer Contracts Directive of 1993, the same thing that we've got in the Consumer Rights Act 2015. So remember here, this is where Kusinova borrowed 10,000 euros from Smart Capital, secured on a home, contracting so that security could be enforced according to the terms of the contract without any review by a court. Kusinova claims that this was unfair, so under what we have in Section 64 of the Consumer Rights Act and Section 62. And the Court of Justice held that the directive, which underpins the same legislation, must be construed in light of the Charter. So it says in paragraph 48, the court has already held that the system of protection introduced by the directive is based on the idea that the consumer is in weak position vis-a-vis a seller or supplier, both as regards bargaining power and level of knowledge. So that's what we've just done last week. But the important thing is that the Court of Justice then bolsters its opinion and saying, we're driven to this, to the result that this contract term is probably unfair because the European Court of Human Rights has held that the loss of a home is one of the most serious breaches of the right to respect for a home. So that's under Article 8 in the European Convention. And secondly, that the person who risks being victim of such a breach should be able to have the proportionality of such a measure reviewed. And then it refers to some of the Court of Human Rights jurisprudence like McCann. Under EU law, it says that the right to accommodation is a fundamental right guaranteed under Article 7 of the Charter, that the referring court must take into consideration when implementing the directive. So you see, it's saying we're being pushed in the decision of having greater scrutiny of the fairness of these terms because there's a human right in play. So that is how the European Court, the Court of Justice of the European Union is starting to think about these issues. We see something similar in Morchillo and Garcia and Banco Bilbao Vizcaya Argentaria. I've pronounced that terribly, I'm sure. Essay in 2014. Here, the Bilbao Bank's term said that if a mortgage borrower defaulted, the whole loan sum would be due. So if you miss a payment, it triggers an acceleration clause, which means that all of the money under the mortgage is due. But the Spanish Procedural Code, Article 695.4, effectively only allowed appeal for a bank, not the borrower, in any dispute between the parties. The borrower at best could get damages, but probably couldn't be able to keep the home. And the question was whether this was compatible with the Unfair Terms in Consumer Contracts Directive, Article 7, which says that there must be an effective means to stop unfair terms. But also, there's the Charter of Fundamental Rights, as we've seen, which in section, Article 47 says that people have a right to an effective legal remedy. So the Court of Justice held that Spanish law was not effective enough and that the contract term was unlawful because it reinforced the inequality of arms between the seller and the consumer. You know, how can it possibly be that the seller has a right to an effective remedy, but the bank does, but not the borrower? It references the Charter of Fundamental Rights in Article 47 as a sort of, again, a way to bolster the opinion, to confirm its conclusion. So I suppose you might say, well, maybe human rights don't matter at all, and if it's just adding what you could do anyway, well, what's the point? But I think that the answer is, like the face up here, that when you can interpret things in more ways than one, it's not always immediately apparent what the best way to do that is. And the values that should underpin our interpretations are probably best guided by international human rights law. And that's what the German court is doing in reference to the Constitution. That's what the Court of Justice in the European Union is doing in reference to the Charter. So what about the United Kingdom? And what about the jurisprudence of the European under the European Convention on Human Rights? We'll go through the Human Rights Act and then look at some of the case law under the ECHR. First, it's probably a good idea to just mention what goes on at common law. So in Entick and Carrington, as you'll know from constitutional and administrative law, we see one of the famous examples of an early recognition of, if not human rights, they didn't necessarily talk about them that way, but certainly civil liberties. This case held famously that the Sheriff Carrington unlawfully searched Mr. Entick's house and papers without a warrant. The warrant that the sheriff said he had wasn't provided for by law. There was no positive law giving the sheriff the right to search through somebody's private property. And the court says that people entered society for the protection of life, liberty, and property, echoing John Locke. There are these sort of basic rights which only positive law could interfere with. So, this was an example of the common law version of the protection of human rights, well ahead of the American Declaration of Independence and the amendments to the Bill of Rights and the French Declaration of Human Rights. So, there were courts already doing it in England. The problem with the common law is that it was pretty weak, and perhaps still remains pretty weak. So you will have also seen Malone in the United Kingdom after where a man was phone tapped, and the question was whether this interfered with his rights to privacy. Similar to ENTIC, not a physical search, but phone tapping. And the Court of Human Rights held that the UK court's failure to protect Malone's privacy right could potentially breach Article 8 of or did breach Article 8 of the European Convention, because there wasn't an explicit protection that allowed the phone tap or the interception of communications in UK law. Viscount McGarry had said that there was nothing in the statute that prevented the phone tap, and the Court of Human Rights said, that's not good enough under Article 8. It needs to be positively provided for by law. The problem, and again, the weakness of the common law and even the system that results from the European Convention, is that swiftly after the European Convention on the European Court of Human Rights judgment, Parliament passed the Interception of Communications Act 1985, which made the interception telephone calls with a warrant or pushed onto a legal footing, and interceptions happened just as often afterwards. So that is a very real problem or limitation in the law. What do you do if Parliament interferes with human rights as well? But nevertheless, we have a strengthening mechanism since the Malone case and since the 1980s in the form of the Human Rights Act of 1988, because this says that the courts have a series of duties, and so far as possible should interpret national legislation, including the Interception of Communications Act of 1985, so far as possible to be compatible with the Convention. So this is what I just mentioned earlier, but just to recap for everyone. The Human Rights Act 1998 says that there's three main things you've got to remember. First of all, when a court is interpreting national law, it's got to do so far as possible to make the law comply with the convention. So that means even bending the words a little bit to try and make them go so far as possible to be compliant with the convention. You shouldn't change the meaning of an act of parliament through interpretation to contradict its basic purpose. But so far as possible as there is ambiguity, you should interpret it to being compliant, because Parliament should not be taken to have intended ever, or without very, very good reasons, to be violating international human rights norms, particularly under the European Convention. Section 4 says, well, if you can't bend the words, if you can't stretch the meaning to have a human rights compliant interpretation, then a court should issue a declaration of incompatibility under Section 4. So then you tell Parliament, well, look, we really think this act doesn't comply with Article 8 or something in the European Convention. Please go and have another look at it. You issue a declaration of incompatibility, and then Parliament usually, in fact, I think only in one or two cases, it has not changed the legislation. That's usually what follows after such a judgment. And under Section 6, courts have a duty to act compatibly with convention rights, along with all other public bodies. So if I'm a local council, if I am the Secretary of State, if I am any public body, including a court, we have a duty to act in a way that is compliant with convention rights. And here's a couple of main convention rights which are relevant for the cases we're about to look at. So very similar to what we've already seen in the Charter, Article 8.1, like Article 7 of the EU Charter, says that everyone has the right to respect for their private and family life, their home and correspondence. And it says there should be no interference by a public authority with the exercise of this right, except such as is in accordance with the law and is necessary in a democratic society. So in accordance with law, right? So rule of law or legality, number one. and necessary in a democratic society, number 2. And then for a list of sort of legitimate objectives: national security, public safety, economic well-being of the country, to prevent disorder or crime, to protect health or morals, or for the protection of rights and freedoms of others. And you see a very similar structure throughout all of the European Convention. You've got your sort of main right, like in Article 8.1, and then you've got exceptions, usually mentioning democracy, rule of law, and a set of legitimate objectives for which, or pursuant to which, it's okay to interfere. Then there's also Protocol 1, Article 1, or sometimes called A1P1, Article 1, Protocol 1, which says that every natural or legal person is entitled to peaceful enjoyment of his or her possessions. Nobody should be deprived of their possessions except in the public interest and subject to the conditions provided for by law and by the general principles of international law. So this is the right to property, but it's mainly talking about personal possessions. So my pen, my glass of water. It's probably less directed at big corporations' productive property. Okay, so the way that these rights have come into UK law are illustrated through a number of decisions, the first one of which was Wilson and Secretary of State for Trade and Industry. For the first time it came that human rights intersected with contract law. And surprisingly, or perhaps not that surprisingly, but remarkably, the first case where human rights come into contract law was not to protect, the little guy, the consumer, the tenant, the employee, or somebody vulnerable, but it was pleaded. Human rights were pleaded in the aid of big, or at least maybe in the aid of a business. So this case was about First County Trust Limited, a loan company, and it argued that the Consumer Credit Act of 1974 violated the European Convention on Human Rights Protocol 1, Article 1. So the Consumer Credit Act requires that lenders state all of the terms of the contractual loan document in one document. So you shouldn't have sort of like one piece of paper here and then see other terms and conditions elsewhere, and then you refer to another book, to try and make consumer credit deals simple and transparent to protect consumers who are borrowing money. It says it's all got to be in one document. And First County Trust Limited didn't do this. It charged Mrs. Wilson a document fee of £250 on top of interest on a £5,000 loan when she pledged her BMW to them. So it had more than one document. It wasn't compliant with the Consumer Credit Act. And the penalty for this under the Consumer Credit Act of 1974 is very strong. It says that the whole agreement is void, and that means that you can't recover your money if you are the business that's failed to comply with the consumer rights. So this meant that First County Trust lost all of its loan money, £5,000. And it said that, despite there being a consumer right, or the consumer right did, in fact, breach its human rights as a business, and in particular the right to property under Article 1, Protocol 1. Now, the House of Lords throws this out and it says there's no violation of Article 1, Protocol 1. Parliament had a good justification for setting the policy in the Consumer Credit Act, even going to the extent of saying that you can't get any of the loan money back, here £5,000, because this was essential to have, hard enforcement to solve a perennial problem of the lack of consumer protection, particularly in credit agreements. But it's noteworthy there that, like Lochner and New York, or like the civil rights cases, human rights were at least being attempted to be turned upside down, being pleaded in aid of a business or a corporation, rather than to protect what you would otherwise think is the weaker party. Okay. So our own John Phillips, Professor Phillips, and Conor Gearty, Professor Gearty over at the LSE, wrote an article in 2012 called The Human Rights Act and Business, arguing that the Human Rights Act wouldn't really have a very big impact on businesses. Give an example like Wilson. They said that many, or point out that many expected the Human Rights Act was potentially going to be bad for business and it could rewrite contract law, but they point out that it hadn't happened yet. And largely that's true. It's probably the case that human rights don't have much to do with business or commercial relationships. But where it's really important, and I think where we still may yet see some significant movement, is for weaker parties like consumers, tenants, employees, and others. And one of the first examples of that in relation to a tenancy was called Lee and Leeds County Council in the Court of Appeal in 2002. So what happened here is Lee and another claimed that their council flats were mouldy, and this violated their rights under the Landlord and Tenant Act 1985, Section 11, which requires that a home is kept in good repair, or the structure of a home is kept in good repair. Previous cases, unfortunately, said that mould was not included in the meaning of Section 11. That the structure of the home is kept in good repair, but it doesn't count if the walls are mouldy. But they argued that the European Convention on Human Rights, Article 8, and the right to a home should update and push the standards up in the interpretation of that right. The Court of Appeal and Lord Justice Chadwick held that Section 6 of the Human Rights Act did mean that the council was a public body. So Leeds County Council or beg your pardon, it might be City Council, was a public body. But that on the facts there was no breach of Article 8 because the right to protection of the home didn't extend, in its view, to stopping mould. But there we have, example of, some the idea that that the convention could be brought into contractual relationships. Yet in McDonald and McDonald, as we've seen, the UK Supreme Court has sort of firmly scotched in its view the idea that this should go very much further at all, at least where there is a statute like the Housing Act 1988, which seems to do the opposite of allowing any further or more protective interpretation of a human rights norm. So again, just remember, I know I said it at the start, but let me just sort of highlight what the facts of this case does. So this says that the Housing Act 1988, Section 21, which gives the right of a landlord or the right of an owner to seek a possession order they don't have to show a good reason. The Supreme Court is saying that when legislation appears to grant a very clear allocation of the balance of power between two private parties, there's nothing left for the Supreme Court to do. Now, it can't go further in interpretation of human rights to contradict legislation. But that doesn't necessarily preclude the fact that legislation could be interpreted to build upon rights where it isn't positively cancelled. So, it could be open if you thought that the right to mold-free houses was a right that wasn't contradicted by legislation, and you thought that the right to housing did require this, or the Court of Human Rights developed that idea under Article 8, then it wouldn't be stopped. But the Supreme Court has cast a lot of doubt on, being very expansive, and probably just reading the way that they frame it, they disagree with what I said, so long as there is a legislative balance being struck in a very clear way. Now, Francois Dubois, professor at Leicester, argues in the impacts of human rights on English contract law that, when we look at all the central cases, the impact of the Human Rights Act is very minimal because of the way in which legal systems tend to absorb foreign principles. He says that it often reflects lawyers' what he calls cryptotypical assumptions, like freedom of contract, commercial certainty, or parliamentary sovereignty. If we have a judiciary, in other words, which is brought up and imbued with ideas that freedom of contract is what matters, that commercial certainty is what matters, and that human rights are really secondary to what Parliament has enacted in its literal terms, then even if there are international human rights norms, or we've got the European Convention, as a matter of sociology, it's unlikely to see much of an absorption of principles from abroad. But what I wonder is, could those assumptions have been changing over time, and will it change with the new generation of judges that are replacing people who were on the Supreme Court before? And I think that there's probably a little bit of room for hope if we think that human rights should be an important part of interpretation of contract law norms. I'll give you an example of where I think this really matters, or an example of a field where I think this really matters, and that's in data protection and privacy. So in Copland and the United Kingdom, a case in the European Court of Human Rights, Copland's emails, websites, and telephone calls were read and monitored by the Carmarthenshire College deputy principal. So that was, the employer, and the deputy principal was sacked and alleged that Copland was having I beg your pardon. Copland was, I think, sacked, and it was alleged that Copland was having a relationship with an employee. Copland claimed that the monitoring breached her right to a private life and correspondence under Article 8. And a breach of the right to privacy if the employer is monitoring your phone calls and looking at what your emails and what's inside your email account, what websites you've been visiting, and all of this is a breach of the right to privacy. The European Court of Human Rights held that there was a breach, and it distinguished between the interception of telephone calls or the analysis of the content of websites visited by Copland, and analysis of automatically generated information to determine whether college facilities had been used for personal purposes, which of itself did not constitute a failure to respect private life or correspondence. So, it's saying it's one thing for, the boss to read through emails at work. It's another thing, potentially, to monitor, if you've got a workplace, monitor ways in which the internet is being used to ensure that it's not looking up websites that are contrary to a college or an employer policy. Right? So automatic searching, probably automated searching, analysis of automatically generated information is different from actually looking through the content or analysis of the content. And it says the applicant in the present case had been given no warning that her calls would be liable to monitoring. Therefore, she had a reasonable expectation, language of implied terms, a reasonable expectation as to the privacy of calls made from her work telephone. But what is the case if you have signed away the right to any privacy? Is it still possible then, or is it possible then, if you have clicked I accept the terms and conditions, or you've signed away a right to privacy, does that mean that you really do lose it? Or is the law going to say, no, this is a human right and the contract term is unfair? So that, I think, is an important hypothetical. What would happen in a case where somebody does sign away their rights? In Foch and Cardiff University, in the Court of Appeal, an appeal was refused when Professor Foch's email was searched, and he was suspended. She was suspended on full pay after she had helped a student with a race discrimination claim against Cardiff University, because apparently it was said that the university had a policy on searching emails. Right, so the Court of Appeal seems to be saying that, well, if you signed your rights away, it doesn't matter. But I think that is highly questionable on whether we look at the European Court of Human Rights jurisprudence or in light of what is now a much stricter standard that we see in the General Data Protection Regulation of 2016. And of course, even though it's even an EU regulation, this is implemented in national law by our own Data Protection Act. So this says in Article 411 that consent of the data subject means any freely given, specific, informed, and unambiguous indication of the data subject's wishes, by which they, by a statement or by a clear affirmative action, signify agreement to the processing of data related to them. So consent under the General Data Protection Regulation has a meaning which is freely given, specific, and informed. And that to me sounds like a much higher threshold for determining what is consent than simply clicking I accept the terms and conditions. It's a much higher threshold for consent than the things that we've learned about in the common law for offer and acceptance and when you get agreement. So that I think is going to be relevant in cases in future. Does consent include clicking I agree to the terms? What about when tech firms like Microsoft, which runs email, Google and Gmail, Facebook, which owns WhatsApp, has terms that say we can take your data and do with your data whatever we want. For instance, for targeted advertising, selling your data to other firms, or simply looking. Imagine if Mark Zuckerberg is just looking through your personal messages. Is that okay? And I think that that's an important question that contract law needs to resolve. It either needs to say yes or it needs to say no. It can't just say maybe. And this is important because the surveillance and level of surveillance that we see in society is becoming ever more extreme, particularly during COVID and as more and more things go online. Workplaces go online, our consumer interactions go online, and even our political beliefs and interactions are all going onto a common internet. And it can be used for good or ill. Shoshana Zuboff, in a book called The Age of Surveillance Capitalism in 2019, argued that big tech has either deliberately or not created a new form of exploitation which is unique to the internet age, based on personal data being commodified, our own personal data, our personal information, and appropriated by big tech. It's like data is the new oil, and the logic of surveillance capitalism, she says, begins with unilaterally claiming private human experience as free raw materials for production and sales. Now, all this data is actually not just sort of taking information that we might not care about so much, but is commodifying the human beings behind the data. And it can be used in very sinister ways. So the most notorious example was in the disastrous political campaigns of 2016, particularly Brexit and Donald Trump's campaign for the US presidential election, which involved the mass appropriation or harvesting of data through Facebook and any mechanism possible online in order to create detailed voter profiles so that people could be more effectively and deceptively and fraudulently targeted with political ads against people's consent in order to manipulate them in voting for things that didn't necessarily match their preferences. And of course, these are huge issues about political control, but they start with contract law. Because when you click I accept the terms and conditions, what does the law say about the extent to which you can still control your data? So the GDPR goes a long way to resolving some of the problems, but certainly the common law and our general interpretation of human rights in contract law is not there yet. Okay, so to conclude, a few conclusions are the following. The law has increasingly responded from the growth of mass enterprise, or responded to the growth of mass enterprise, by replacing contracts, or simple 19th century models of contract law and bilateral bargaining, with more and more democratically determined rights. So the law has increasingly said that some rights just aren't for sale. Not everything is put into the market. Not everything is subject to contract terms of whatever. It's not like anything goes. And it seems likely that simple signatures or clicking boxes will not, and arguably they should not, be deemed to be true consent, particularly when we're talking about valuable human rights like privacy, data protection, and all of the other rights that we talked about today. Because just saying I agree to the terms and conditions isn't real consent. It's fake consent, and it should be treated as such by our law. Contract is a relatively simple mechanism of governance. It's a relatively simple governance structure, but it's one which spreads out across the whole of the economy and affects so many aspects of our society. More sophisticated governance structures also exist, and they emerge where people can also have ongoing voice in shaping the institutions that have power over their lives. And that could include public services, like phone companies, water companies, electricity companies. It can include big tech. But one really good example where I think things are a tiny bit more developed are universities. And so this is where I want to get back to, the document that I asked you to sign right at the beginning, or click I accept the terms and conditions for, where you gave up all your rights to the lecturer and I could determine, any terms. And of course, as I said last week, this is all a bit of a joke. But it illustrates, I think, an important point. Because when I first started these lectures about, I think I'm getting old now, it was probably about 5 years ago, I showed the lecture handouts and what I was proposing to do to Professor Phillips and the other lecturers at the time. And I said, here's what I want to do. And they said, it looks all fine, but this clause where you ask the students to sign, I accept the terms and conditions, and that the lecture terms can be varied in any way. I'm not sure that we can have that one, because if you were actually going to say that you could do whatever you want and students had to follow all these rules, it should really go to be approved by the academic board of the university, which is sort of like an elected, or at least partly elected, body within the university. Represents both staff and students at the moment. And they set policies on education. And one of the reasons that happens within universities is to ensure that curriculums and the rights of students are properly safeguarded. And there are mechanisms of voice and there are mechanisms of governance which are much more sophisticated, ultimately based on voting rights, which ensure that at university you're not being exploited by a lecturer who tries to make you do anything. So, the university governance structure goes beyond contract law. It goes into what I call enterprise law. It's the law of the governance of workplaces like universities, public services like universities, summed up, for us in the King's College London Act of 1997, Section 15 in particular gives people voting rights, although that's a bit more complicated these days. And so my larger point is that when we're looking at the protection of rights, we do need to go beyond contract and into governance. And that, I'm afraid, is for another year and another course. So to summarize everything that I've said in the lecture today, first of all, contract law is really, and also not just the lecture today, but the last few weeks. Number one, contract law is really the law of contracts. There's not just one monolithic rule of set of contract law for offer and acceptance and terms and vitiating factors. There's actually lots of different kinds of contract law, depending on where people are in society and the rights that they ought to have. There's different rules and rights that have emerged for different kinds of transaction. Number two, the right to contract and private autonomy is a value of primary social importance, but it's not the only important right. Contract isn't the only important right that we have. There's also other human rights like to fair pay, consumer protection, data protection, privacy, housing, and all rights should be interpreted together in order to serve human freedom. The third main point is that there's no inherent value, I think, in fake autonomy. So where people talk about freedom of contract, this is often a one-sided ideal that's used to thinly veil the exercise of power by large corporations or large governments. So, where contract terms result from the arbitrary exercise of wealth and power, whether by a government or a corporation, the courts and contract law should be very careful to guard against abuse. And the fourth point is that in a just society and in a democracy, power is in the hands of the many, not the few. So that's an idea going back to Pericles in ancient Athens. And the law of contracts is essential to advance goals of a just society as well. So I hope I've persuaded you that contract law certainly isn't boring, certainly just isn't all about business, and does connect to a much, much broader ecosystem of the law. It connects to labor law, consumer law, company law, enterprise law, public law. There is a seamless web, if you like, in which contract law sits. And it's one of the most interesting and important topics there is. So I hope you've enjoyed this. I've enjoyed doing YouTube for the first time with you. And I hope to see you all perhaps next year or the year after. I'll go on to Teams now, but have a great reading week and yeah, enjoy the rest of first year. Bye bye.